Okay, hello and welcome back to Criminal Procedure. Today we're looking at prosecuting crime, and we're focusing on who is vested or which body is vested with that power to prosecute crime. And we're also going to look at something that maybe, as you know, if you haven't done the slides, that you certainly average citizens aren't aware of, the notion of private prosecutions as opposed to public prosecutions. Okay. So it's important that we look at this power. Remember when we spoke about our history, our judicial history in the sense, we said that as private citizens and as society and community evolves, we give up various of our rights. And in terms of criminal law, we gave up our rights to prosecute or seek vengeance and justice in our own names. And we gave up that power to the state. And that part or that organ of the state, which is vested to stand up and fight a case on a victim's behalf from a criminal law perspective, is essentially the National Prosecuting Authority. And so it's important for us to know what the National Prosecuting Authority is, what it's made up of, and what it is it supposed to do? What is it actually supposed to do? And through legislation and other enactments, how is it empowered and how is it meant to do and serve the purpose it is meant to? So if you look at the National Prosecuting Authority, it's a creature of, it's a constitutional, it's given life through the Constitution rather. So it exists because by virtue of the Constitution, as we see in section 179. And beyond that, the scope of its existence is found in the National Prosecuting Authority Act. And as a starting point, we have to look at who the individuals are or the people, the humans behind the National Prosecuting Authority. At the very, very top, you've got the National Director of Public Prosecutions, who is the head of the NPA. And below her, in this case, at the moment, her or him, you've got Deputy National Directors of Public Prosecutions. So below that top tier, then you've got Directors of Public Prosecutions, which are situated various of the different high courts, and below, and with them, you've got Deputy Directors of Public Prosecution. And below them, you've got public prosecutors. And the public prosecutors are who you're going to be facing or meeting, rather, in your day-to-day practice of law as a defense attorney. Otherwise, if you are appointed as such, you could yourself be appointed as a public prosecutor. And the public prosecutors are the ones that you see in the magistrate's court, in the criminal court of the magistrate's court. And the state advocates are what you'd see in the high court, but all working for the state, for and on behalf of the state. Now, the powers of the National Prosecuting Authority, very, very simply, is to institute criminal matters and pursue them. In other words, conduct the trial, conduct criminal proceedings. And that means, for our purposes, so if the investigation part of this criminal procedure system has been done and the docket comes to the desk of, and we'll start at the very bottom, of the public prosecutor, this public prosecutor decides whether or not there's a case to be brought here. So yes, like we said, and as we used in the examples in the flow diagrams, etc., it is a very necessary role that they play. It is the link between the investigation and the end result of justice, right? One cannot exist without the other. So this notion of instituting criminal proceedings starts at the public prosecutor, where the public prosecutor at ground level looks at this docket, looks at this police file, this investigation file, and determines what charge to be laid. And that's just a very, very simple starting point. But over and above that, and if we're taking our extension from what we covered last week when we looked at the De Beer versus the state case as regards jurisdiction, we can see that the role of the NPA as a whole is much more than just instituting criminal proceedings, starting the trial, if you will. So if we start from the top now, so we looked at what happens at the bottom. If we start at the top now and we talk about the National Director of Public Prosecutions, the very head, this person determines prosecution policy. And this is what we are prosecuting, how we are prosecuting. It also goes towards a professional code of conduct for those that work for the National Prosecuting Authority. Policy directives, in other words, here's the policy, but here is how we interpret and implement that policy. It can further intervene when policy directives are not complied with. So if an instruction or a directive does come from the NPA and prosecutors at lower levels, or even the deputy directors at lower levels aren't following through, there can be some sort of disciplinary measures involved there as well. And if we're going to compare with what we discussed when we spoke about jurisdiction and the De Beers case, the Director of Public Prosecutions at the very top, and including his deputies, can make decisions on whether or not to prosecute, which we'll talk about a little later, but more specifically, geographical jurisdiction. Geographical jurisdiction. And I think we've spoken at length about why geographical jurisdiction is important. And we saw in the De Beers case that the National Director of Public Prosecutions does have a discretion to move a matter from one high court to another. They do, and that's in terms of the powers vested in this person through the National Prosecuting Authority Act. And as you see through this series of lectures and today's slides and audio, that there may well be very good reason as to why it is necessary or preferred that a matter be moved from one locale to another. Various reasons to explore in that regard. What is important for us and what we'll bring about, talking about when we talk about the difference between private and public prosecutions is this thing about review a decision to prosecute or not to prosecute. Because that leads us into the question of, do prosecutors have a discretion to prosecute? Do prosecutors have what is called prosecutorial discretion? In other words, does that mean does it mean that every case that is reported and investigated must come to trial? Or do prosecutors have a discretion to decide, well, this one I'm not laying a charge, I'm not formally laying a charge, we're not bringing it to court? What do you think? You can raise your hand and unmute. At this point, any thoughts on whether or not the prosecution has a discretion to prosecute?
Good morning, Miss Pamji.
Good morning. Good morning. You can go ahead.
Well, I think they do they do have a discretion in terms of whether or not to prosecute, especially if they see that a particular matter does not have substantial or enough substantial evidence for them to prosecute.
Okay, so let's then talk about pros and cons. Is that a good discretion to have, or is it, or can it lead to abuse and corruption? Okay, I can't look at the chats and the screens at the moment. So please, if you have a point, just raise your hand and then unmute yourself. Someone raised a hand just a moment ago. Yeah, go ahead, Tabo.
Oh, hi, Miss P.
Hi there.
I think, yeah, I'm agreeing with Tinashe. I think they do have a discretion to prosecute. Also, going back to what you spoke about earlier, I think about compulsory prosecution, since South Africa does not fall under compulsory prosecution. I think with also regards to whether there are pros and cons, I think there are also negative sides to it because prosecutors, I mean, I think there was also a case about biasness. They can be biased on what matter to bring before the court and what matter to not bring before the court, which can have a very negative impact to the justice as a whole. I
But
think
that's certainly
not
one
not
of the,
basic.
sorry, go ahead, go ahead.
No, I'm done.
Okay, now that's certainly one of the criticisms that is constantly leveled against the National Prosecuting Authority. That I've reported my matter, it's been investigated, and this is, from a number of victims of crime, and the matter's just not coming to court. There've been no arrests, been no formal charges, and what in the public's mind is the guilty party, this person is just walking around free, and where's justice for me? Now, the prosecutor will come back and say, no, no, there's no such thing as compulsory prosecution. I have prosecutorial discretion, and I'm exercising my discretion not to prosecute. And correctly, as we've been alluding to, the concern is, well, this is corruption. This is corruption. Uh, Accused, well, not even accused persons, but suspects, people suspected of having committed crimes, can get away because of this thing called prosecutorial discretion. How would that be resolved? How is that resolvable? How do we reconcile that? And this is where we're starting to talk about accountability of the NPA. And we'll look a little bit more closely just now at, and you would have covered this in the audio, this notion of what is prosecutorial discretion. Now, Tinashe touched on it, and he said that if a prosecutor has a file before him or her, and there just is not enough evidence to make a prima facie case, it would actually be a disservice to justice and to the victims of that crime if the prosecutor were to pursue a criminal charge and a trial in those terms with that scant evidence, unreliable evidence, etc., before him. Now, the reason for that is that once a matter is heard and tried and a decision is made, a court can only make a decision based on the evidence before it. And if the state, and only if the state, has made a prima facie case for which the defendant has not offered a suitable defense, right, or wavered that version of events from the state, it's only under those circumstances that a court of law would find the accused person in that scenario guilty. So when a prosecutor goes to court with incomplete, unsubstantiated, uh, unreliable evidence, certainly running the risk of obtaining a not guilty verdict. And this, I need you to hold this in the back of your mind for when we start talking about the section on pleadings. Because if we look at a scenario where this case happens, the accused person is found not guilty, some years later, other evidence comes forward, and now a prosecutor wants to lay a charge again for that same offense initially. He may well be faced, when the accused person is asked to plead, with a pleading of atrefar acquit or atrefar convict. Now, that simply is what is the principle of double jeopardy. But we'll talk about that in a lot more detail in another set of lectures. But the point we're trying to make is that once a matter is finalized, and in a sense, for what we're discussing here, a not guilty verdict on evidence may well be the end of the matter. And as far as procedural fairness and justice is concerned, one cannot be tried again for a matter that you've already been tried for. And in the case of atrefar convict, you've been found guilty and you already served time. Or in the case of atrefar acquit, where you were found not guilty and was legally absolved of any guilt. So there are pros, yes, and there are cons there. All right, someone had their hand, sorry. Who had their hand up? I'm just trying to see. Any comments before I move on? So that's the question. Can the state refuse to prosecute? Yes, it can. But as you'd have seen from the slides, from the audio, and from the notes, the prosecutor who declines to prosecute must offer proper and sound reasons for their decision not to prosecute. Okay? And one of those reasons would be, well, there are no witnesses, we don't have statements, none of the witnesses are reliable. Or, yes, we've got evidence, but it would appear that this evidence was unconstitutionally obtained. Whatever the case may be, all leading towards whether or not we are able to make a prima facie case. We as the prosecution are able to make a prima facie case. But we also understand that there may be circumstances or situations where, despite there being a prima facie case, right, or whatever the reason, a public prosecutor may still decline to prosecute, even with good reasons. Even with good reasons. So forget whether or not there was a prima facie case to be made, right? Even with good reasons, a prosecutor may decline to prosecute. But us as citizens or the victim of this crime may feel extremely aggrieved. And so to prevent citizens from taking the route of vigilantism, right, or vigilantism, built into our constitutional democracy and built into our Criminal Procedure Act is something called private prosecutions. Private prosecutions. And what private prosecutions allow is for victims of crime or their next of kin, and you'd have seen what the requirements are to qualify as a private prosecutor, to institute criminal action in their own name, where a public prosecutor has failed to do so. And yes, there are requirements to qualify and to allow for that to happen, but we do cater for it in our system of justice to avoid actual injustice. So if you look at Section 7 of the Criminal Procedure Act, one of the main things regarding private prosecutions is that the person seeking to prosecute must have locus standi. And that could be because you yourself were the victim, or you were the spouse or other next of kin, child, etc., of the victim of crime. And you'll see from the way in which matters are reported in the law reports, you're accustomed to criminal matters being the state versus. But in private prosecutorial matters, it is the name of the private prosecutor. In other words, the person with the victim or the person with locus standi versus the accused person in name. Okay. Another interesting thing is that in order to institute a private prosecution, not only must you have locus standi, but you must also have in your possession what is called the certificate of nolle prosequi. So every time a prosecutor makes a decision not to prosecute a particular matter, they create and issue what is called a certificate of nolle prosequi, stating that we will not be prosecuting this matter, and in there must be their reasons for it. And once you've got in your possession that, then you go to the clerk of the court, of the criminal court, with that certificate, with 2,500 Rand, and with your drafted summons, which essentially would be the charge sheet emanating in a private prosecutorial fashion. Now, there's also several concerns or real issues that we also need to talk about when we talk about private prosecutions. And the one major thing is costs. Costs. Who joined this profession to make some money? Any of you hoping to earn money as lawyers? I would hope so. I would hope so, right? And whenever like you're around the dinner table and you're talking to people and they'll tell you jokes, oh, you're going to be in the big bucks, you're going to be charging 2,000 rand an hour, 5,000 rand an hour, and whatever the case may be, you're going to be rolling in the bucks. So aside from what the rate is, legal fees are expensive. To retain an attorney for a matter, to retain an advocate if necessary, costs a lot of money. And in criminal matters, that burden of the cost of legal fees doesn't fall to the victim of the crime. That burden of the cost falls to the state. The state absorbs that by instituting the action on its own behalf and paying its prosecutors and state advocates to run these matters on behalf of the state, which is meant to not only protect the interests of the states, but also the interests of the victims of crime. And so when one embarks upon a private prosecution, it means that you as the individual victim of crime has to foot the bill, the legal bill. And so yes, it can become very, very costly. And depending on what the outcome is or what the ruling of the court is, not only if depending on whether you win or lose, not only could you possibly be responsible for your own legal fees, you could also be responsible for the legal fees of the accused person, the person that you have brought to court. So yes, although this notion of private prosecution does exist, and it is in a sense available and accessible, we need to put a question mark on accessibility when we add in the cost factor, the cost factor. But you've seen the videos that I've uploaded, particularly regarding AfriForum, which is a private body set up and otherwise funded to institute private prosecutions in matters where the state has declined to prosecute. So they're not looking necessarily for funding from the individual victims. They've got as an interest group, as a public interest group, in a sense, outside funding to run these matters. So that's also something important. But you must also appreciate the value of having such a mechanism as private prosecution in our law. The role then, I think it's becoming more and more evident that there is a role to play. As we move along the various steps on that flow chart, we're seeing that there's a role for everyone, and there are many, many role players in this thing called the system of criminal justice. We've seen what the police do. We've now seen what prosecutors do. But we also see that there's a role for the public. And whether that public is you and I as witnesses or you and I as victims of crimes, but all of the members have a role to play, a role to play. And the better we play our role, okay, the better or easy or more seamless it is to bring a matter to trial in a sense. Now, before we move on to the two tutorial questions, which I need you to cast your mind to, an important question is, can criminal matters prescribe? Can criminal matters prescribe? We know about a 3-year prescription period for, let's say, contracts, or if you're suing in delect. Can criminal matters prescribe? Any thoughts? Okay, let's start out by saying that criminal matters do prescribe. They can prescribe. But unlike civil matters, you've got a 20-year period for that to happen. Except, of course, so we can say that there is no prescription for murder, treason, robbery, kidnapping, rape, genocide, and more recently, sexual offenses, and look at the case of Levenstein and others versus the estate of the late Sidney Lewis. Now, in that matter, it had to do with a sex offender, an abuser. It was only later in life, when the victims of this abuse were mature adults and gained the courage and the strength to bring a complaint, a criminal complaint against him, that this matter was brought to court. And we can understand, given the nature of these types of offenses, the complexity involved in investigation, in the willingness of witnesses to come forward, that it may well be necessary and actually just not to allow these matters to prescribe. You've read enough newspaper reports, journal articles, particularly around the psychology of sexual offenses and what that does to the victims, and how much it takes for a victim to gain the courage to be able to come forward and speak out. We also know things about genocide, and genocide, which you will cover if you do international criminal law in your fourth year of study. These war crimes, warlords can go for generations, and only when there's been a coup or there's been some sort of rebellion, and only when these leaders are brought to before the Hague, before the International Criminal Court, can the matter be heard and these victims of these sorts of crimes be rectified. And that period can certainly be well over 20 years. So there is some logic to that and reason for that, why we'd have this. All right, so before we move into the tutorial questions, any questions from yourselves thus far on the notes and the audio? Okay, so let's deal with the first question. South Africans became aware of the notion of private prosecutions when State Prosecutor Alfred Gerinel announced his resignation from the National Prosecuting Authority in order to join AfriForum, with an intention to prosecute in a private capacity those crimes which the NPA decide not to prosecute. As a practitioner, you may be approached by a client who wishes to institute a private criminal prosecution. Write an explanatory essay discussing this avenue. This is a very simple explanatory type essay, informing your client you're going to tell me what it is that your client wants to know. So how did you start? Anyone? This is one of those questions that we would say marks for peanuts. Go ahead, Michael.
Sure, thanks, Ms. B. So I started by saying that there are two forms of private prosecution. First is prosecution by an individual on the basis of a certificate non prosecu in terms of Section 7 of the Criminal Procedure Act, and a private prosecution under statutory rights in terms of Section 8. Okay. So then I went on to elaborate on private prosecution under statutory rights in terms of Section 8 because it's a smaller section. So it covers, it's not very intensive like the material that you cover when going through it. And then I further went into Section 8 now, which is the private prosecution by an individual on certificate of no prosecution, if you want to say. Is that okay?
Yeah, so far so good. So far so good. What would your client further need to know? So you'd start off
Well,
by telling them what it is,
yeah.
where the power comes from, right?
Yes.
What
So the
is
CPA.
involved, right? So you'll be talking about the practical aspects about, like we said, the Nola Prosecutor certificate, the deposit,
Yeah.
and also the costs involved.
Okay.
So legal fees, etc. So as I explained what it would mean, and you can get this from the notes more fully, what it means if you win your case, what it means if you lose your case, instances. So going into a bit more detail now, instances where the state can take over the matter, you know, if the state may want to take over the matter, things like that.
Yes.
Remember, when you're doing an essay like this, or you're giving advice in this fashion, explanatory essay discussing the avenue, you've got to give the positives and the negatives. So yes, this is a wonderful avenue. It's what is its purpose? Sorry, did you talk about the purpose? In other words, what gap in the law or what gap in justice is this meant to fulfill? Like I was saying, it prevents vigilantism, or it's designed to prevent vigilantism. It still allows for a measure of justice, but justice through legal channels, lawful channels, etc. So you're looking
Well, yes, I did. I spoke about that, and then I also spoke about it being more, not only a system of not only a system whereby uh, it only incorporates like isolated instances of citizen participation in the criminal justice system, but it could entail also instances where private persons are called upon by police officials or whatever to assist in a citizen's arrest in terms of Section 47, and that kind of I went along those lines.
okay, that's taking it a bit further than we were looking for, but it is extending. You're correct in that it extends the power to assist or be involved in justice and to another level. So you just got to be a little careful when you do make your references to Section 47 and private citizens arrest. But that will come more clear to you when you look at that in next week's set of lectures. All right, but otherwise, that is how you would have a well-rounded explanation there. So this is a matter of controversy, which certainly is what any discussion around the NPA seems to be. The prosecutorial decision to decline to prosecute is both specifically and systematically exercised to such an extent that proportionally fewer cases are placed on the court roll each year and fewer still are brought to trial. So this quote is basically a criticism against the National Prosecuting Authority, leaning towards saying that it's failing in its duty for whatever reasons, whether it's purposefully declining, purposefully in the sense of in a malafides fashion, deciding to fail to prosecute, to exercise this lawful prosecutorial discretion for unlawful, unjustifiable, and unjustifiable reasons. Prosecutorial discretion rests in the hands of the NPA and its appointed officers. There has been considerable concern and criticism regarding this. In an essay, critically discussed the independence, accountability, and performance of the NPA in relation to its core function of prosecution. All right, how would you deal with this? Again, a pretty cut and dried format. Go ahead, Michael.
Sorry, Ms. B, I just wanted to clarify a bit more just before we move on from the previous question. When we talk about intervention by the state in like certain instances of private prosecution, do we relate that with where a private prosecutor fails to appear for the matter, and if the matter is of quite significant consequence in that instance, then the magistrate or the judge could intervene by saying that no, we can't, it's a very important aspect of law that's going to be discussed or whatever, so we'd rather go forward and continue with it, and we'll get a substitute almost prosecutor. No.
This failure of the private prosecutor to appear means that when you institute on a private prosecution, you are paying your lawyer, right? When your lawyer doesn't come to court, there are consequences for your matter. Your matter can be quashed, your matter can be struck off the roll, etc. The matter can now be put to bed finally simply because your attorney did not turn up. So you as an attorney who is instituting this matter on behalf of a private citizen, there's great responsibility upon you to be at court on the day. Now,
So there's no interrelation.
I beg your pardon. Unless you have a legitimate reason, illness, for example, your own illness, for failing to appear in court, that matter won't just automatically be rolled over. And in civil matters, very, very often, and in various other matters, even when private attorneys are acting as defense attorneys in criminal matters, I've seen a tendency for attorneys just not to come to court. And it is very annoying for all of the parties concerned who are prepared, and instead an attorney doesn't turn up. Now, it is disruptive and it is annoying. And what's also important to know is that in terms of criminal law as well as civil law, if these sorts of failures to appear are repeated, we talk about one particular matter, right? If this sort of failure to appear happens, eventually the accused person can say and raise that this matter should be quashed and prevented from coming forward. So now we're talking about the state prosecutors, where state prosecutors just aren't prepared and keep asking for adjournments, right? And I have a right for this matter to come to finality, but the state is never prepared. So please find me not guilty. That's another avenue. And
thank you.
in my own practice as a defense, when I was in practice ages ago, that is how we won one of our cases. Well, I won one of the cases because the state just wasn't ready. Adjournment after adjournment after adjournment. And even though I never had to actually argue any law on the matter, a win is a win.
Yeah.
So what you're talking about when you're talking about what we're talking about when we say where the state takes over a private prosecution, this is because the National Prosecuting Authority, through its deputies and prosecutors and senior prosecutors, will be keeping a close eye on these private prosecutions, which are few and far between. And depending on how that matter is turning out, may decide that no, we ought to be taking over this matter, and it should no longer be a matter for this private citizen to foot the bill. There is actually enough evidence here. And when the state makes that decision, as a private individual, you can't say, no, I'm happy to carry on with my own attorney. You have to actually acquiesce. All right. Michael, do you have another question?
No, Ms. B, thank you.
Okay, so let's look at this next question. Again, another essay question, this now coming from a critiquing point of view. So as much as you're discussing law, you're also discussing political tensions and this notion or this criticism that the NPA is derelict in its duty to prosecute. Any input? So there were some articles that I put up for you regarding that. And if you read those articles, it will give you an idea of what the tensions and also some studies. One of them is a study or a report on this notion of failure to prosecute, and accountability in that sense. So what should you be dealing with? So one thing you'd be picking up on is the NPA truly independent? Or has it proven to be susceptible to political and other influences in exercising its its discretion to prosecute? That's one of the things. The other thing is accountability. Is the NPA a power unto itself? As much as we say that it is independent or ought to be independent, which is judicially necessary, the question we then were asking is, does that mean that they are a law unto themselves and offer and cannot be sanctioned by a higher power? Is there a higher power? Is the National Director of Public Prosecutions accountable to anyone for the failings, misgivings, performance, lack of performance of his or her department? Yeah, so that's essentially what the considerations in writing this critique. How did you deal with it? That's essentially how you ought to have dealt with it. Any input? Okay, so sorry, I'm looking at the chat now. I don't know who J1 is, but J1 says the prosecutor has a choice whether to prosecute or resolve the matter through mediation. Now, that's an important question, and that or an important point, because that sort of ties in with what you're discussing in your assessment one question. But there is a discretion, there is a difference between the decision not to prosecute and resort to mediation versus the decision not to prosecute at all. In other words, not even offer an alternate means for justice or an alternate means for a vindication. Okay, so bear that in mind also when you're dealing with assessment one. All right, any further questions? No. Okay, so the slides and audio and readings and tutorial questions for next week's session have been uploaded, securing the attendance of the accused at court. And there are two very interesting tutorial questions there. I've split that lecture up into the methods, and the following lecture will be on use of force in effecting arrest, because we need to have a much more substantial discussion on that with those tutorial questions. So please, as you've been working through the slides and the audio and prepared for discussion of the tutorial questions, keep up the momentum, keep up the good work, and I will see you all again next week. All right, thanks everybody.